Good morning, everyone, and welcome to this webinar on parental leave. It's absolute pleasure to have you here with us as the WorkLaw team. And I'm joined by my colleague and friend, Bruce Robertson, who will help me answer any of your tricky questions.
Good
Uh,
morning, everyone.
just want to say that this webinar is set up. We're only going to spend half an hour on this topic, but we thought it would be helpful because we were getting such an enormous amount of queries on the WorkLaw helpline that we thought it would be worthwhile, firstly, drafting a template to assist the WorkLaw subscribers, and secondly, to hold this webinar to assist in discussing and hearing each other's challenges that we're having in drafting a parental leave policy. How I'm going to do this is I'm going to give you a little bit of background and context to parental leave and where it comes from. I think you probably know, but I thought it'd be worthwhile just to summarize the Constitutional Court judgment. And then I'm going to go into some of the challenges that one faces in drafting this policy. And I'm going to be referring to our template, not taking you through step by step. That would be terribly boring. So what I'm going to do is I'm going to take you to some of the critical clauses in the template, as well as the application form we've drafted to assist you in relation to your drafting of your particular policy. Of course, please put any comments or questions you've got in the chat. And we are recording this, and as always, it'll go onto the WorkLaw website afterwards for you to access should you need to. For those that are not, there are a few people online that are not WorkLaw subscribers that have been invited to attend who have shown an interest. Please contact me afterwards if you want to access the website. We do a short access period, trial period, should you wish to access any of the WorkLaw information, which everyone who uses WorkLaw, but I just say that most of our subscribers here, Bruce, have been with us for more than 10 years,
Yeah.
which really reflects how the value that we trust we add to our subscribers. So I'm going to go straight into it because we want to keep this short and sharp.
So,
Uh,
Tanya, just to comment, you are going to touch on where the amendment bill
yes,
varied from the Constitutional
correct.
Court.
Correct.
Correct.
So let me
Yeah.
go straight into that. Thanks, Bruce. You can see Bruce has to keep me on the straight and narrow and remind me of everything all the time. But he's allowed to come in and correct me at any occasion, as he does for myself and Alan, might I say. So let me go straight into it. We know that at the end of last year, the Constitutional Court um, um, handed down the judgment of the Van Wyk. It's referred to colloquially as the Van Wyk judgment, in confirming the judgment of the High Court that had been issued 2 years prior, finding that the sections of the Basic Conditions of Employment Act in relation to maternity leave, surrogacy, and adoption leave were unconstitutional in that they discriminated against specifically fathers and to some extent adopting parents and surrogate parents. So essentially what the court did is they said these sections 25 to 26, 27, I'm not going to go into the specific sections, but they're unconstitutional, and they basically have drafted a reading in clause that employers need to adopt in the interim until Parliament enacts new legislation to correct the unconstitutionality of the BCEA. So the Constitutional Court has a reading in provision, and it's this I'm going to summarize what that read in is. And then I'm going to take you to as Bruce correctly said, take you to the amendments that were gazetted in at the end of February this year for purposes of comments by the end of March, and how those adjust or adapt the Constitutional Court judgments. And it's on that basis that we've made our recommendations in terms of the policy. Now, coming to the Van Wyk judgment, this is what it said in summary, is that if you are a parent, you become a parent, it's irrelevant of your gender, your marital status, all that. If you become a parent, and you are a single parent, alternatively, a parent who is, you might be in a parental relationship, but you are the one that is the only one that is employed, you attract 4 months parental leave. So I want to say, so if you're single or the only one employed, you adopt 4 months of parental leave. And this is becoming a parent through birth, through adoption, or surrogacy. So you immediately attract those 4 months. If you are in a parental, you become a parent by birth, surrogacy, or adoption, and you are in a parental relationship, and you're both gainfully employed, what that means is you would share 4 months and 10 days parental leave, apportioned as the parents decide, but neither parent can take more than 4 months. Okay, so one parent will at least get 10 days, the other one, and the other one, but it would be apportioned as the parents decide. What the Concord said is if the parents are in a parental relationship, that you've got this parental relationship, they are both employed, but they cannot agree on how they're going to apportion the leave. What happens then is it gets apportioned equally as possible between them, with the proviso that if the parenting is through a birth, then the birthing mother, that's if it's not pretty obvious, it's the mother giving birth, would be still entitled to the BCEA portions for purpose of the birth period. That's up to 4 weeks prior to the birth and 6 weeks thereafter. So they would still be entitled to that period, but the 4 months and 10 days would be split equally, with those 10 weeks falling to the mother, which is pretty much half the time anyway, to the birthing mother. So that is essentially what it does. And obviously, if it's through birthing and surrogacy and the parents can't decide, it's apportioned equally between them. Now, essentially, the Constitutional Court did mention the Unemployment Insurance Act, but did not actually pronounce on how that should be amended. So that's something which also was a bit odd, because obviously one would think that parental leave would attract UIF and would echo what the Constitutional Court said, but they actually didn't go and do a reading in for that particular piece of legislation. Now, so that was the end of last year. Now for
and they also, Tanya, on adoption leave, just mention what the Concord didn't deal with the question
they said essentially that the portion of limiting adoption leave to children under 2 is unconstitutional, but they did not pronounce on what age would be constitutional. And I'm going to deal with that now. So essentially what we've got here is a fast forward to the amendments that were gazetted in February 2026. And they have largely adopted what Van Wyk judgment has said in the new amendments to the Basic Conditions of Employment Act. And they've, in addition to that, provided amendments to the Unemployment Insurance Act. So essentially, what we've got in terms of the BCA is a couple of variations from the Van Wyk judgment, and there's 3 critical ones that one needs to take into account when looking at the amendments. The first one is that I think I like the amendment because I think it's a good one, is that if 2 parents who are employed become parents through birthing, and they are having a discussion about leave and they cannot agree, it is the birthing mother that can determine the apportionment if they can't agree. But obviously with her taking up to 4 months only. So she can't take the full 4 months and 10 days. But she gets the power to decide if there's no agreement in relation to that leave. So it empowers her to do that. But obviously that doesn't extend to adoption and surrogacy parents. So that's the First Amendment. The Second Amendment is that the amount of parental leave that can be taken by any new parent is limited to one one session of parental leave per annum. So you can't take 2 or 3 parental leaves per more than one per annum. So you can't take 2 or 3 unless you're the birthing mother. Although I don't quite practically understand how that would work, since one is pregnant between 9 and 10 months. So anyway, it does seem a bit odd having to have to put that in. But I guess they didn't want to discriminate against pregnant moms, and there may be a situation of birthing moms of having miscarriages or things like that. I suspect it's to accommodate that. The third change
Tanya,
in
so just to
yes,
understand that, so do I understand you correctly? If you're a man and you give birth to 2 children in 1 year, and if you were entitled to leave, you'd only be entitled to that leave once in that year.
parental leave once a year, correct.
Yeah. Okay. Yeah.
So that is my understanding of it, Bruce, and I think it's
Yeah.
yours as well. Is that right?
Correct. Yeah.
The third amendment, that the third provision that is brought through the amendments and is not in the Van Wyk judgment is linked to what Bruce raised earlier, being the adoption leave, the adoption age, and they have thought it appropriate to say that any child under the age of 6 that's adopted would attract parental leave. So that is an interesting one. I don't know how they landed at six years, but that's what they did to address the concerns raised by the Constitutional Court. In relation to the UIA, obviously, there's been draft amendments to that. And if you're a single parent or a sole contributor, you are entitled to, they've actually specified very particularly, being 4 weeks, being 17.32 weeks paid parental benefits. So that would be 17 weeks or 4 months that the parent would be able to claim from the UIF. If you are 2 parents that are gainfully employed and obviously contributors as well, you'd be able to apply for 4 months and 10 days parental leave between the 2 of you. In other words, that's in total between the 2 of you that you can claim. I think it's going to be an administrative nightmare to kind of coordinate that, and I suspect lots of changes to their systems. But anyway, the one thing before I go into the issues, and I'm actually going to share our site, so I hope you can see that. So I just want to share so you can actually see our site as WorkLaw. I trust those that are subscribing to WorkLaw can see it, have accessed it already. But certainly, the one thing we want to mention before we take you through some of the challenges and how we've addressed them in our template is that remember that until you amend your policy stands as is. So if you've still got an old policy that provides for maternity leave, then of course that applies to you as a company because that's your policy. So until you change it, your current policy applies. However, there is a risk that you could be challenged by one of your employees to say this is discriminatory, etc., and potentially successfully so because of the court's outcome in Van Wyk. So I'd love to hear if any of you had received any of those queries or questions, or whether people can take parental leave. Now, I'm going to.
So Tanya, just to
Yes.
highlight the point. So the fact that the Van Wyk judgment is there, and the fact that an employer may have a maternity paid leave policy does not automatically now extend that to all parents
Correct.
who would then be entitled to paid leave. That particular employer still has to amend its policies to provide for that. Because as you know,
that's certainly my understanding of how it would work, Bruce. And
we've had helpline queries from organizations that just purely as a result of the Van Wyk judgment and the amendment bill, you've got fathers saying, right, I'm entitled to paid leave under your policy as a result, when that employer hasn't yet amended its policy.
yes,
So,
correct. So
okay.
it's quite and it's difficult for employees because I think these things require a lot of consideration. So it does take time to consider and apply your mind to your policy, particularly if, and I'm going to get there, if it's particularly beneficial to in terms of maternity leave at the moment. So I do think a lot of employers are still considering the implications. So this is I've actually put it up on our screen rather than just simply do a PowerPoint because I thought it much easier to show you where to find things, etc. Can you see this okay, Bruce?
Yes, we can see it very
That's
clearly.
great, very clearly. I've made it quite big, so hopefully it's good to the eye. I want to, it's a very nice, it kind of gives you an explanation at the back. But the first thing I want to do is one of the challenges that might come up is who is it exactly a parent? That has come up in our discussions with some of our clients. And certainly if you go to I'm not going to go through, like I said, I'm not going to go through bit by bit with this because it'll be terribly boring. So I'm going to go straight to what is a parent. And we've given a very specific definition of a parent because we think that the one thing employers must do is have a very clear policy in terms of who they recognize as a parent. We mean the birthing parent, mean the employee who's pregnant and gives birth. A non-birthing parent is obviously the other party to a birthing parent, who's not the birthing parent. And then we've got the adoptive parent, means an employee who adopts a child in terms of the Children's Act and is 6 years of age or younger. So we've adopted, although it's just an amendment, you could probably
Amendment,
adopt
yeah.
this in the interim.
Mm.
Hey, Bruce?
Yeah, agreed. Yeah.
So we just aligned it with the amendments. And obviously, if the amendments come out differently, you would immediately amend your policies accordingly. Is then you've got your commissioning parent and saying what that would mean. So the other section that we want to put in is around what a parental relationship is. And we've kept that again very specific. And it means obviously a child from birth, adoption, or surrogacy, and that's the birthing mother and the biological father. So we've been very specific there. The registered parents of an adopted and the registered parents of commissioning, because you don't want
Just
a situation. Yes, Bruce?
just a note, Tanya, that's a biological father, and we've included under the Children's Act because not all biological fathers would be entitled to leave, and there are certain, and we don't want to go into all the details. It would be too complicated, but it limits biological fathers, unmarried biological fathers, in certain circumstances. Yeah.
No, absolutely. So so we've kept the definition as nice and tight, easy to identify. So when you as an employer need to interpret it, it's easy to do. The second thing we want to address the other next question is the impact. What is the impact of a more generous policy of a company? So what if you want to have paid maternity leave? We know currently that maternity leave does not attract pay in terms of the BCEA. It's unpaid. It's unpaid leave. That's the protection. You get 4 months unpaid leave. But a lot of companies we know offer more generous maternity benefits, such as 4 months. I've even seen as much as 6 months. Hey, Bruce. I think there was one client that actually offered as much as 7 months paid maternity leave. And the question is, how do you manage this? And if I go take you to clause 6, I'll take you straight there. This is your entitlement, etc., as I've explained to you earlier. And so the adoptive, that's all around that. I'm not going to take, like I said, take you all through what I've explained already. But remuneration during parental leave, we've given you two options: the unpaid option, and where there's a company paid benefit that's attracted to taking parental leave. So the unpaid one is pretty clear, is that if you're a sole parent, you get 4 months unpaid leave. And if you're a dual employed parent, you would get 4 months and 10 days, unless the parent taken by the other parent. So you get 4 months and the other parent splits it. Then you've
And
got,
obviously under those circumstances, those parents would claim UIF.
yes, and then encouraged to claim your parental benefits. It's this one I just wanted to highlight with you, is that we've put in a lot of options around this, is subject to the employee having completed 12 months continuous service. And a lot of companies have conditions to people getting paid parental leave. So it might be 12 months, it might be 24, it might be retaining the person, however you frame it. You could get paid the difference between the UIF amount and paid, or I've seen people pay the full amount. So we've given you various options. Again, I'm not going to take you through this. You need to decide whether any of this is of assistance to you and adapt it for your needs. But it's very important that we provide this. Is
So
the
Tanya, so what you're saying is that you've got to equalize, and because if you don't equalize under your policies between parents, they're likely to be attacked at some stage. So however much paid leave you're going to give, what you're saying is that you should probably equalize that between parents.
I think so. And
Whether
there's a
it's
couple of
100%, whether it's 75%, and
percent
obviously there are
exactly.
huge financial consequences to this for employers to think about how many employees are going to be applying for this leave, and they're going to have to decide whether it's full, partial, etc.
Exactly, and I think there's a couple of challenges around this. And Bruce, as you know, I'm not a huge fan of this judgment. I can say that I say that publicly because I think there's going to be it's going to cause huge disruptions, and I do think it's going to be in the long term harmful to women. And I'll tell you why. There's two reasons why employers are going to think twice about extending this out from their maternity benefits to parental leave. The first one, obviously, it's going to be a lot more expensive for them because men who take leave will now also attract such paid benefits. And I'm assuming companies are going to have to get actuaries in, or AI these days, hey, Bruce,
Yeah.
to determine what the cost associated with that is. The second thing is, I do believe just practically, if you are in a parental relationship, you have a baby, and you have to decide which leave, who's going to get what leave. There's no doubt that parents are going to choose leave from the company that offers more. So the companies that are offering more generous pay around parental benefits are certainly going to be carrying the can in terms of the leave taken. And that's an unfortunate circumstance that just is going to manifest due to the realities of how people think in terms of taking this leave. So that's going to be a huge issue in my view. So when it comes to more generous policies, you are going to very likely have to treat all parents equally in relation to that particular benefit. The third aspect that I wanted to deal with is around the challenge of having parents who are employed, both employed, but in different organizations. How do you deal with this practically? Is what happens if how do you get the information? How do you know what your employee is telling you is true? And this is where we've actually, if you go to our website, we have, I'm going to share it, developed what we refer to as I hope I'm sharing the right thing here. I think I am. There we go, the parental leave application form template. And we've developed a template for you to use. And hopefully this will be of assistance in that it will look at the information that we think will hold up to scrutiny in terms of section 27(1)(b) of POPIA in terms of requesting information. And the reason for that is you require information to verify the application of this parental policy and the parental provisions in what will ultimately, in the Van Wyk judgment, and will ultimately be enacted. So what we're suggesting you do is that you have a form such as this, but I'm not going to again take you through it. It indicates the type of parental leave. You might want to say a check when they've recently applied. That could be relevant or not to you, especially if you've got benefits that are limited to taking it only in certain periods for limited to one every 3 years, etc. You've got the information around two parents. Now, the one thing that is crucial is that you should ask for information on the other parent's leave. So you need to get the name and surname of the other parent, the employer, the contact details, and the date that the other parent is going to take. in order for you to verify the information on this application form when they ask for specific leave. Okay, so then you say if you're a single parent, you need to say how many leaves you're taking. And there's also provision. I know some employers allow for you to take additional unpaid leave in relation to parental benefits. But certainly our view is that this is quite crucial in order for you to ensure that you can verify it against what your employee is applying for in relation to the number of days of leave. Now,
And Tanya, just to highlight, and you do require both parents to sign that form.
yes, that's correct. So you've
So,
got additional
in a
leave.
sense, the other parent consents to you verifying that information with that parent's employer.
That's correct. And you can
Correct.
see the form actually provides for it. That's what
Yes.
we are suggesting. Very importantly, you can ask for supporting documents. Often there's an agreement, and it's encouraged that there's an agreement between the parents on the allocation of leave. And then finally, that they obviously acknowledge that it's captured correctly and that you may contact the other employer. And you could put here that if you if you've if you've if you capture incorrect information knowingly, this could be fraud, etc., that you could possibly put in as well, because I do think there's going to be a lot of disputes around this. I think this is going to have a huge, there's just going to be a lot of disputes around how this is actually captured and done. So I do think hopefully this is useful to you. And that you're able to use these forms, etc., as a guide when you develop yours. Now, one final thing I do want to say is I did say I was not a fan of this particular this particular judgment and what's happening here. And I do think that one of the things that's going to happen is that women are actually, because of what companies are going to do, they're going to probably start curtailing these benefits. Sadly, I do believe that we're going to have a situation that women are going to have less leave and less benefits associated with giving birth going into the future. Bruce, before I take questions, is there anything you want to add?
I mean, just one comment is that I think there's a possible problem that's going to emerge, and that the amendment bill captures a whole bunch of amendments to the LRA, the BCEA, the Minimum Wage Act, etc. And because of the problematic nature of some of the other stuff around unfair dismissals and so on, we do have a concern that it's going to take some time before that amendment bill is finalized. So if the amendments to this leave is held back because of disputes over the other stuff in the amendment bill, that means the Concord's interim reading continues to apply for as long as there's no change to the BCA. And as you've highlighted, the Concord's interim reading has certain problems which have been improved upon by the amendment bill, but that Concord interim reading continues to apply currently for as long as we don't have a finalized amendment.
Yes, absolutely. And there has been one question from Prince is, when do they start applying this? It's immediately. It became effective immediately when the judgment came out.
Yeah. But
So,
I can only think that there'll be, I mean, if you had drafted your own policy in terms of the amendment bill, which rather than in terms of the Finvate judgment, I mean, I can't believe a court would find against you on that. I mean, I just
uh,
think
but
so.
yeah,
We're in an interim period. Yeah. So, I mean, one has to take a sort of overall approach, I think, to this.
but it is important to think about these things at the same time, hey,
Yeah.
Bruce,
Yeah.
because you do want to give effect to it as soon as possible, having thought about the implications for your organization, because you also don't want to be challenged. You don't want employees to feel that you're not
Correct.
doing anything. There's
Yeah.
been a couple, we have some interesting questions around this. We often get questions such as, does that mean that a dad who's a single dad can get 4 months? Absolutely. It's irrelevant of your gender. If you adopt as a dad, you get those 4 months. Uh,
Yeah.
it's I know it's like a bit of a change in mindset around how this works. But that's exactly the point that the Constitutional Court was making, is that you can't assume that the woman is the primary caregiver. There has to be give that you can't make that assumption up front. Yeah, so are there any other questions? I don't see a lot of questions coming through. I see people have asked questions and said, no, that you've answered that. So hopefully they have been answered. There's a few that have come through. Are there any other questions that anyone has on this important development in our law? No other questions. Don't see
But
no
just to, I mean,
more hands.
just to add the comment, which I think I said earlier, but just to highlight it again. I mean, the fact that the interim Concord's reading currently applies and it's legal does not in itself change your internal policies. So if your policies provide for paid maternity leave, a father comes along, yes, he's entitled to the 4 months, but he's not entitled to paid leave until you change your policies to
Yes.
provide for that. So he would, in that instance, have to apply for UIF unless you've changed your policies. Yeah.
Okay. So been a very short webinar. Please give us feedback on how you've enjoyed this and if it's been helpful. And certainly if there's any others you'd like us to do, happy to engage. We look forward to seeing you on our helpline for some further queries that you may have. Again, like I said, if you are not a subscriber of WorkLaw and you've been invited to this webinar, please do contact Tanya
Yeah.
at WorkLaw, and I can certainly help you to connect with WorkLaw.